Thank you, Amish. First of all, good morning and Happy New Year to everyone. Welcome to our first virtual study circle meeting of 2021. Our today's topic is Procedure of Defense Mechanism in Disciplinary Cases of ICAI. Let me introduce you to our today's speaker, Mr. Arun Saxena ji, 61 years of age with total experience of 34 years, out of which he has 28 years of experience as partner in Messrs. Saxena and Saxena Chartered Accountants since 1986 to December 2014, and 6 years of experience as managing partner in Saxena and Saxena Law Chambers Advocates, New Delhi since 2014. He is a fellow member of ICAI and practicing advocate. He is also a member of Corporate Law Committee of PhD Chamber of Commerce, Committee for Insolvency and Bankruptcy Code of Associate Chamber of Commerce, executive member of National Company Law Tribunal, Bar Association, New Delhi. He was technical director of training program for officers of Office of Officers, Official Liquidators, Ministry of Corporate Affairs, New Delhi, organized by ICAI in April 2009. He was convener in Company Law Research Committee of NIRC of Institute of Chartered Accountants of India 2010-11. He was advisor to Company Law Study Group of Northern India Regional Council of ICAI, New Delhi 2007-8. Pusa Road CPE Study Circle of Northern India Regional Council of ICAI, New Delhi. He is also visiting faculty at Indian Institute of Corporate Affairs of Ministry of Corporate Affairs. The seminar conducted by Institute of Chartered Accountants of India and its branches and study circles, public sector undertakings, and PhD chambers of commerce. Now I request Ms. to please proceed further.
Thank you, CA Manthanji. Respected CA Advocate Arun Saxena ji, all my core committee members present here, all respected members of the profession, a very warm welcome to all of you for the today's webinar meeting under the topic Procedure of Defense Mechanism in the Disciplinary Cases of ICAI. I want to brief you all about the defense mechanism before the advocates start this session. As we all know, as we all aware, ICAI, we all aware that it is established on 1st July 1949. Even it's before the Republic Day. Our forefathers knows the importance of the chartered accountants. So now many people says, why this regulatory on us? Why this code of conduct or code of ethics on us? Because of our creditability. Main thing is the creditability. Because this is the foundation of our core profession. Even once our Honorable Prime Minister said that CA signature is most important than that of our signature is most important than his signature. So it's the society expectation that why the code of ethics is on us, but the people want we should be transparent and work as a transparent. And the first edition of code of conduct, first edition of code of conduct came in the year 1963, and our ethical standard board, जो ICAI का ethical standard board hai, it came into the vision in 1975. Even the before the board of ethical standard of for the accountant that was established in the year 1976, but our board came in 1975, and in 2001 our code of conduct become the code of ethics because ethics have the liberal meaning. Now in the recently 2020, the meaning they have revised the code of ethics after the gap of 10 years into the two parts. Today we will not discuss about the code of ethics, but we will see the defense mechanism. What is the disciplinary proceedings and what's the defense mechanism for the member and what's the process. So now it's over to Advocate Arun Saxena ji, and my sincere thanks, and I welcome you for taking your valuable time for the today's webinar. Sir, now you can start your deliberation. Sir, you are on unmute.
Thank you, Amish ji, for inviting me on this topic on behalf of your Andheri Oshiwara CPE Study Circle. I am very thankful to the study circle for organizing such a specific topic which is rarely come up in the study circles. And it is a time when we should understand what kind of the procedure we should adopt when any member receives such communication from the institute. First of all, I will thank all your team members, Deepak Madlecha ji, Nikhil Polwal ji, Manthan ji, for Manthan ji for giving a very good kind words for me, and Amish ji for getting me involved in their WhatsApp group and continuously in touch with me about the program. Thank you so much, Amish ji.
Thank you, sir.
First of all, as you rightly said, that today we will not discuss much about the code of ethics. We will discuss the disciplinary mechanism. What is the procedure? What are the rules, regulations, Act provides for the disciplinary proceedings? Who are the authorities? What are their powers? What can they do? And what are the powers and what are the defense available with the members? This is very important to understand. And one thing very good you said in the brief background of our code of ethics and disciplinary proceedings, that's credibility. Why code of ethics is necessary? Because to maintain our credibility. I understand we all members do their best of their ability, the professional assignments. But sometimes, unintentionally, something happens. Some things in audit report, you miss something unintentionally. So we have to see that unintentional things will never go against the members. This is very important. But if there is an intentional mistakes, intentional act any member does, for that purpose, disciplinary committee is there, disciplinary board of disciplinary is there, full mechanism is there. See, unintentional and intentional mistakes, I will give 2-3 examples. See, 3 sections are very important when we draft the audit reports and we audit the balance sheet. One is section 185. Number 2, I am not going into detail. Section 185, loan to the directors. Second is deposits. Number 3rd is investments. And number 4th is related party transactions. See, I will advise to all the members, viewers, that we should see the application of all these sections and we should report the matter if there is any violation. So these are the apparent things, and normally these things are coming into the disciplinary proceedings. Non-compliance of accounting standards, non-compliance of the provisions of Companies Act. So these are the things the member should take care when finalizing the reports. Now I'm coming to the dispute. See, what kind of the, I am appearing before the disciplinary committees, board of discipline, and what kind of the regular general cases comes. Number one, I can categorize in 2 things. One is from the client against the members. See, client and against the members, normally what happens when there is a dispute between the clients. promoters. And to settle the score, their score themselves, they make the chartered accountant as a scapegoat, and they file the complaint on one point or other. See, if you see the dispute, I will advise one thing. Why dispute arose between the promoters? Promoters complain that the chartered accountant has uh, uploaded the form DIR 12 or PAS 3 for the allotment of the shares and the appointment of the directors without having actual meeting of the board of directors and without uh, following the procedure under the act. What I will advise to the members, you do the uploading of these forms, but you should have all the documents in your file while uploading the form. For example, if you are uploading the form for the DIR 12, you should have the copy of the notice of the board of directors, evidence for dispatch of the notice, then attendance sheet, copy of the minutes, and DIR 12. If you have all the documents in your file, nobody can touch you for the non-compliance of anything. This is one thing. Second thing is, sometimes we see that the auditor is discussing the reports and promoters are apprehending that auditor will not change their stand and they will give the qualified report. And that time also, what they do, they remove the auditor and they file the complaint against the auditor for some reason or others. Now I am coming to the mechanism, defense mechanism. See, whenever we receive any notice or letter from the institute giving the details of the misconduct or violation of any act and asking you to give the reply, see, we should not be panic, because we have to see the notice in two point of view. One is as a professional compliance. Number two is legal compliance. We have to understand what are the legal compliance required for the notice you receive, and how to respond the notices and how to act during the proceedings. So now I would like to share my PPT. So friend, disciplinary mechanism, I have divided into the two parts now, because who are the authority who takes the action against the members for any misconduct? One is ICAI, second is NAFRA now, because NAFRA is also notified now. And I will discuss briefly later stage of my presentation, NAFRA provisions also. So ICAI and NAFRA, these two bodies take the action against the any misconduct of conducted by any member. And ICICI has divided in three departments or three organizations. Number one is Directorate of Discipline, and two is Board of Discipline and Disciplinary Committee. The Directorate of Discipline is just a reporting and complying office. Whatever information or complaint comes, that is done by the Directorate of Discipline. They have to act according to the rules and regulation and provisions of the Act of the Chartered Accountants Act. And then they have to put up the proposal their PFO, prima facie opinion, before Board of Discipline or Disciplinary Committee. I will discuss later in all the three these organizations or department in detail. And NAFRA is established under Companies Act section 132, and it is notified in 2018. Rules have also been notified. NAFRA has started working. NAFRA has given so many verdicts also, and I will discuss briefly the procedure of the NAFRA also. Now, if you see the disciplinary mechanism, I have showed the directed discipline. Directed discipline is the department in the Institute of Chartered Accountants of India, where all kind of the information or the complaint comes. It is a complete department. They have to receive the information. They have to inquire about the information received. They have to evaluate the information, and then they have to investigate the matter in-house, and then receive the give their prima facie opinion on the basis of the documents, etc. So up till PFO, the work is given to the directed discipline. Then when PFO is formed, then if PFO is in the PFO, director or the opinion that the misconduct is as per the first schedule, then it will place the matter before the Board of Discipline. And if the misconduct falls under the provisions of the second schedule, then they will place before the disciplinary committee. However, if misconduct involves first schedule as well as second schedule, then the matter will go to disciplinary committee. See, what is the role of directed discipline? And Section 21 provides, on receipt of any information or complaint, along with the fees, against the member, then director discipline shall arrive a prima facie opinion. Here, two things are very important to understand. The director discipline can take the action on the information on the complaint only. What is the information? What is the complaint? I will discuss in detail. But if the director discipline has no information and no complaint, director discipline cannot take any action or cannot proceed in any proceeding to form the prima facie opinion. First of all, I will discuss the information. What is the information? See, Rule 7 of the proceedings says that the information is any written information containing allegation against the members of firm received in person or by post or by courier by the directors. Let us pause here. It's very important to understand. First of all, information should be written information. Number two is the director should have received in person, by post, or by courier. So, according to me, director discipline cannot take any action on the information which is not received in person or by post or courier. It means if something comes in this email, he cannot. it cannot, rather on the information, they cannot proceed further. For proceeding further, first important thing is the information should be in writing. It should have been received in person, by post or courier. And for the purpose of the information, what normally director discipline does, they send the form 1 to the sender of the information, so that they can receive the information in form 1 that will be converted into the complaint, and they can proceed with the proceedings against the members. And because if form 1 is not filed, then it will be very lengthy procedure for the disposal of the information, and sender will not be involved and will not have any right of the representation in the proceedings, and sender will also not get the copy of the orders. So, and further, very important, anonymous information shall not be entertained by the director discipline. This is a provision under the rule. So, to sum up, the information is a written information which is mandatorily received in person, by post or courier. So, friends, we have seen so many complaints, of course, so many action on the basis of some advertisement in the newspaper, some news clips in the newspaper, or any other information. According to me, director discipline has no power suo moto unless they receive the written information in person, by post, or by courier. So please see, on the basis of the public information, on the basis of the media information, the director discipline has no power, whereas NAFRA has the power to act against the member on suo moto. This is written under the rules of the NAFRA. So far as director discipline is concerned, they, according to me, they do not have any power suo moto. What is the complaint? Complaint has to be in Form I. Form I is given where all the information is required, like name of the complainant, name of the member or the form against which complaint is made, address of the member against which complaint made, and it gives the details of the allegation in the complaint. Friends, if you receive any communication from the institute director discipline for some kind of the allegations, first of all, you should see the form 1. And form 1 gives all the information on which you can have the first and primarily objection. I will discuss later. Again, complaint should be filed in person, by post or courier. So no email is necessary, or no email can be entertained. If complaint is filed on behalf of the central government or state government or any authority, statutory authority, then it should be filed on behalf of not the below rank than joint secretary. And complaint should be signed not the below rank of under secretary. On if complaint is filed on behalf of the firm or any company, then it should be supported by resolution, whether from the partnership firm or whether from the company. So first of all, whenever we receive any complaint against us, we have to see the form 1, who has made the complaint. If it is an individual, it should be signed properly. If it is a firm, it should be signed along with the board resolution, resolution of the partnership firm. If it is a company, then it should be supported by the bold resolution. Normally, invariably, we have seen in so many cases, the Form 1 is not supported by the bold resolution. So whenever you receive such a communication, immediately you have to make the objection on such Form 1. This Form 1 is not correct, and these are the objection. It is not, so proceeding initiated by the DD is not legally valid. So this is one thing you can make the objection. What director does after receiving the complaint or information, they will scrutinize the complaint. And if it is in order, it is supported by Form I, it is supported by the prescribed fees, then they will allot a unique number. And if it is not, then they can ask one opportunity given to the sender to rectify the default and then allot a unique number. But if complainant does not reply, then director discipline will not take any action against the defective complaint. What is misconduct? Misconduct is defined under section 22, and it says that any act or omission provided in the schedule, any schedule of the act, first schedule or second schedule. Second is an inquiry by DD into the conduct of the member of the Institute of ICAI under any other circumstances. So this is the professional and other professional misconduct is defined in the Schedule 1 and Schedule 2, and the other misconduct is also defined in Part 4 of the Schedule 1 and Part 3 of the Schedule 2. I will briefly discuss, I will not go into the detail, but give the just idea what are the Schedule 1 and Schedule 2 applies. The Schedule first is divided into the 4 parts. First part is applicable for the professional misconduct in relation to the CA in practice. Second part related to the professional misconduct in relation to the CA in service. Third part, professional misconduct in relation to the members of the institute generally. And fourth part, other misconduct in relation to the member of the institute generally. And other misconduct means, first of all, this is applicable to all members, whether they are in practice, they are in service, they are not doing anything, but they are member, or whether it is related to the professional work or it is not related to the professional work. But this is part 4 is applicable to all. In this, two kind of the misconduct are covered. Number one, if member is a guilty in any civil or criminal court, not exceeding 6 months of the imprisonment, then they and this is part 4th misconduct. And second is any act done by member of the institute, whether related to professional work or not, which gives the disrepute to the profession. This is most of the allegation comes under this clause also. Similarly, second schedule also, this professional misconduct in relation to the CA in practice. Part 2, if it is misconduct in relation to the member of the institute generally. Third is other misconduct, as we discussed in the first schedule. Question comes, once if this complaint is filed and the complainant wants to withdraw the complaint, whether he can withdraw the complaint or not, that is the question. The answer is, according to the law, the board of discipline or disciplinary committee has power to allow the withdrawal of the complaint any stage of the proceeding. But friends, one is very important here to understand that board of directors, board of discipline and disciplinary committee can can refuse to withdraw the complaint in certain circumstances. This is settled if, for example, if complaint is filed against a member and there is a settlement between the complainant and the respondent, and then they file the complaint application for the withdrawal of the complaint. Application has to be filed before the directors of discipline. Directors of discipline will put up before the board of discipline or disciplinary committee. They will consider it. They may allow to withdraw the complaint, but they may refuse in certain circumstances. For example, if the misconduct is such a glaring, uh, then this resolution of the dispute between the complaint and respondent will not come into the way in taking action against the member. Board of directors will consider, board of discipline or disciplinary committee will consider the nature of the uh, misconduct and will consider whether it is in the interest of the profession to get to allow the withdrawal or not. Now I coming to the procedure. What procedure Directorate of Discipline adopt to uh, make the proceedings, and how proceedings are conducted? Let us understand that. First of all, on the receipt of the complaint on the information, the copy of the complaint is to be sent to the member. Or if it is complaint is against the firm, it has to be sent to the in the name of the firm at the registered address of the firm. In case of the firm, on receipt of the complaint, first they have to give a declaration to directed discipline that on behalf of the firm, who is the responsible partner. The name of the responsible partner is to be given to directed discipline. In case within time provided, firm does not give any responsible name of the responsible partner, then in that case, all the partners at the time of commitment of such offense shall be responsible for the allegations or the misconduct. So, friends, whenever you receive a complaint against you from the directed discipline, then first of all, you have to see whether the complaint is in individual name, individual partner's name, or in firm's name. If it is in firm's name, you have to immediately inform to the directed discipline that such and such partner is responsible for such complaint. This is one thing. Second thing is very, very important here, that written submission by the respondent on the complaint. The DD will give you the time for filing the written submission um, on the complaint. Normally, time is given 21 days. But on the special circumstances or request made by the respondent, additional time can be given, but not more than another 30 days. So you have to see the complaint and file your written submission. How you have to file the written submission, that I will discuss. First of all, you have to see that what kind of the complaint, who has made the complaint, under which clause, under which section, under which schedule the complaint has been made, and what are the allegations raised by them. Number one, here I will suggest all the viewers, unfortunately, if you receive any complaint against you, first of all, you have to see Form 1, details of the allegations. It is given in form, the serial number, clause 5 of the Form I, all the allegations. Normally, the brief allegations are given there, and the complainant attach a detailed complaint as an annexure. You have to see the annexures also. First of all, you have to make two things very important. One is you have to see whether complaint is signed and verified properly or not. This is first thing I discussed, that if it is signed, it is filed by or on behalf of the company or firm, it should be properly supported by the board resolution or firm's resolution. And if it is filed on behalf of the central government or state government, we have to see it is on behalf of not less than the rank of joint secretary. It should not be signed by the person not the below the rank of under secretary. So this is first thing you have to see on the complaint. Second thing, you have to see the each and every allegation. First of all, I will suggest, on receipt of such complaint, don't get panic and give any small or shortcut reply to the DD. No, you have to understand the entire complaint, what are the allegations they have put, and you have to see whether all the evidences or documents in support of the allegations are there along with the Form 1 or complaint sent by the DD. If, for example, I am saying that the complainant says you have not followed the accounting standard, uh, such and such accounting standard, and he has not placed the evidence where it is to be reported, whether, and he has not means attached with the complaint the copy of the financial statement. Or second example I will give, suppose you are the auditor of concurrent auditor of the bank, and bank has filed a complaint against you that you have not reported the outstanding overdue in bills properly. If it is written there, it is not supported by the ledger, or it is not supported by any evidence, so this complaint is not complete. You have to write immediately, not the written submission. Immediately you write to the director discipline that we have received the complaint, but such and such evidence, such and such document is required to give my written submission on the complaint. In absence of such information, or in absence of such document, it will be very difficult for me to give the written submission on the complaint. On receipt of my letter, the DD can give me the information. If director discipline says, no, we will not give you the information, we don't have any information, and you file the written submission, then you can file the written submission. But this point, which you have written to the institute, that these informations are or evidence are necessary to give the written submission, to complete written submission on the complaint, will help you in taking in appellate stage, because there you can give proper opportunity, or natural justice was not given to me. So first of all, you have to examine the form 1 and complaint. And if you see there is any missing document which are very important to support the complaint, you can write to the DD. Second thing is the complainant, the written submission shall be given to the complainant for rejoinder. Then, first of all, one thing very important is rejoinder. Complainant will file the rejoinder, and copy of the rejoinder will be given to the respondent also. So you have to first make the objections, then you prepare the written submission. In written submission, you have to give the, what we have seen is written submission has been given generally. Generally, you can't give the written submission. Written submission, in written submission, first of all, you should give the background of the matter, if you know, then brief facts. Then you give the proper preliminary submission. Preliminary submission means, suppose some evidences are required, you have written to the directed discipline, they have not provided, you make a preliminary submission in written submission that I have called for this information which are necessary to response on the complaint which are not given to me. So this thing, preliminary submission, you have to mention in the written submission. Then parawise. In parawise, I have seen so many written submission, very general sentences are written. No, you have to first of all deny everything specifically. Then you have to give the background on the basis of which I am saying that I am not a guilty. There is no misconduct. So you have to place the evidence in support of your written submission also. Third thing is very important, sir. Here I will give two examples. Normally, misconduct matters comes. One is communication. NOC is not given by the existing outgoing auditor, and new auditor has not taken NOC. So friend, first of all, make it clear, law does not provide that the new auditor, incoming auditor should have the NOC from the outgoing auditor. Only communication is required. Communication, and that too, communication is required from the outgoing auditor. If suppose you write the communication to the outgoing auditor does not reply, you have to wait for reasonable time, and then you can accept the assignment and conduct your assignment. There is no harm, there is no violation of any act. Even if you have written to the outgoing auditor, and outgoing auditor has made some frivolous ground, and you have to apply your mind, it is your call whether the objection raised by or observation made by the outgoing auditor is proper or not. If you see this is a frivolous thing, then you can even accept the assignment and do the assignment. It's not that you should have the no objection. And second thing is important is you have to in this regard, you have to see that their audit fees is paid to the outgoing auditor. So these kind of the thing, if you have already communicated to the auditor, outgoing auditor, and you have not received anything and you accepted the assignment, and allegation is you have not obtained the NOC, it's wrong, illegal. You have to just attach with your written submission the copy of the communication made to the outgoing auditor. So while preparing the written submission, members should give their defense and along with the evidence. If you will not put the evidence, again the complainant in rejoinder will say it's a frivolous, it's a bald, it's a baseless defense. We have to give a concrete written this defense. It's not necessary you should give a bulky reply. No bulky reply. You have to give the very concrete reply along with the evidences. Evidences are must. It will serve your purpose. It will give you the benefit during the oral arguments. If you have given the complete evidences, this will give you a very big strength in the written submission. One more example I can give. In one matter, allegation was that statutory auditor has signed the balance sheet while he was also a shareholder of the company. Normally, our thinking is the auditor cannot hold the shares of the company in which he is the auditor. But if you see the law says he should not have the substantial interest. Substantial. When we receive this complaint, then we have to see what law says. Law says substantial interest should not be held by the auditor. Substantial interest is not defined under the C Act, but we can borrow from the Companies Act or SEBI Act, but not less than if you have the auditor is holding not the substantial interest, that is 20%. If we take the Companies Act definition of the substantial holding, then 20%, he is not violating any act. He is not doing any misconduct. So when we have written the written submission against this complaint, we have said that the auditor was holding 9% shareholding, whereas he was not holding substantial shareholding. And whenever he had the substantial shareholding, he has resigned. So these kind of the defense you have to make out. Only you can make if you read properly the allegation, you see what is the law, you see what is the evidence available with you, and written submission. First written submission is very important, my dear, because on the basis of this only, the director discipline will make out their PFO. So written submission has to be prepared very, very carefully. First submissions, then facts, then you have to deal with each and every allegations. And in the end of that, you should say that in view of the above submissions, the complaint has to be dismissed with cost, like that. So after written submission and the rejoinder receipt from the complainant, the director discipline will form the PFO. And copy of the PFO shall be given to both the parties. Both the parties mean complainant or the respondent. So then respondent has to file again. They say written submission, but I will say that it is the objection on the PFO. So both the parties can file the objections on the PFO. So when PFO is before you, suppose there were 4 or 5 allegations. In three allegation, director discipline says you are not guilty. But in one, they say you are guilty. So you have to again make the objection and file the written submission to director discipline on the PFO. And in that, you have to reiterate what you said in your first written submission and give the more evidence that you are not the guilty. And after receiving the this PFOs, the complainant also filed the objection. Now I come to the what PFO will be considered by the BOD and the disciplinary committee. So if we brief it, if we brief the whole procedure is, first copy will be given to the respondent complaint, then respondent will file the written submission, complainant will file the rejoinder, then DD will examine the complaint with respect to the written submission, rejoinder, and other information. Then they will form the PFO. Copy of the PFO will be both the person, and both the parties are free to file objections or written submission on the PFO. Then what will happen? If it is in the DD will place the PFO before the BOD and DC. DC means disciplinary committee, BOD means board of discipline. Board of discipline, if agree with the PFO and as per PFO, the person is non-guilty, then it will close the matter. And if BOD is not agree, if the member is found guilty, then BOD will give the opportunity of being heard. The notice will be issued on the PFO, and then to the complainant and the respondent, they will be heard, meetings will be held, and then the order will be passed by BOD. And if it is not guilty, then they will close the matter. Order, BOD has power to reprimand the member or to remove the name of the member up to 3 months and impose the fine up to rupees 1 lakh. And if it is disagree, BOD or DC is disagree with the PFO, then they will refer back to the BOD for the further investigation, and then again opportunity will be given, investigation will be done by the disciplinary directorate, and then again it will be placed before the BOD and DC, and then again it will be heard by the DC and BOD. And DC, in case of the DC, they have the power to remove the name of the member up to no limit. They do not have any limit. They can remove the name of the member of any limit, and they can impose the fine up to rupees 5 lakhs. So what is the procedure for the not proceeding before the BOD and DC? Procedure for adjudication. Friends, if PFO is placed before the BOD and DC, then if they agree with the PFO of the DD that member is non-guilty, then matter ends there. No need for any proceeding. If DC or BOD thinks that matter is they don't agree with the opinion of the PFO of DD, then they will ask the DD to further examination. But one thing is very important. Board of directors or disciplinary committee, if they differ with the opinion of the director discipline, then they have to record the reasons therefore. They cannot say we don't agree like this. They have to give the reasons why they don't agree with the PFO of the DD. They have to give the reasons. High Court has given the clear-cut judgment that if the opinion of the BOD or DC to defer the opinion of the PFO without any reason is illegal and void. So BOD and DC has to give the specific reason before making before disagreeing with the opinion of PFO of DD. So now, why procedure will be adopted by BOD? Law says that BOD shall apply or follow the summary disposal. I believe most of us will be aware of the summary disposal. In summary disposal, on the basis of documents or the opportunity given to the members, matter can be decided. Here, the recording of evidences of witnesses is not included in the summary procedure. But, friend, Section 21C of CA Act provide clearly that Director Discipline, Board of Directors, and Disciplinary Committee shall have the same power as are vested in CPC in respect of summoning and enforcing the attendance of any person and examination him on the oath, discovery and production of any document, receiving evidence on affidavit. In these three things, the BOD, DD, and DC will have same power as they are in CPC. So my humble submission, my humble suggestion to you is that the summary, though Rule 14 says summary, suggests the summary disposal for DD, for BOD, but 21C give wide powers to BOD for summoning and enforcing the attendance of any person, discovery and production of any document, receiving an evidence of on affidavit. Friends, here I will give an example. How BOD can go beyond summary disposal. See, suppose there are some evidences or some documents which are forged, appears to be forged, or which are fabricated, or documents which the existence is in dispute. Then in these circumstances, beyond the summary disposal, BOD has power under Section 21C to record the evidence of any person as witness, making him cross-examination, and then pass the relevant order. So in some of the cases, some defense is taken, that objection is taken other side, that it is a summary disposal, witnesses cannot be examined. But my view is the board has enough power, board or disciplinary committee has enough power to examine the person on oath, or making him cross-examination, any evidence on the affidavit, in case BOD or DC is of opinion that this is the fit case for the cross-examination, and the decision or justice can be given only on the examination of some witness. So, friend, though it is the jurisdiction of BOD, if you have any matter, you have the case where you have challenged the existence of the document appears to be fabricated, documents appears to be false, that you can make the application, you can write in your written submission, you can write in your objection to the PFO that the to have the justification and judgment and justice, the examination of witness is necessary, then the board of discipline will consider your request, and if they are in opinion, they will allow the examination of the witness. So it is not that always they have to follow the summary disposal. In certain circumstances, they can go beyond that, and they can allow the examination of the witnesses in the proceeding of the board of discipline. Then what will happen? Fix the date of first hearing not later than 45 days from the receipt of the PFO from DD. Friend, this is also a very important rule in which they say that director discipline sends the PFO to BOD. After receipt of the PFO from the DD, the board has to fix date of first hearing not later than 45 days. So here is also a catch. If there is a delay, there is a delay of 45 days, you can make the objection that it's a violation of the rule by the BOD, and that objection you can take during your oral submissions. First hearing, first of all, the BOD, presiding officer, will read the charges against the respondent in first hearing. What are the charges? They will read before the respondent, and they will ask a question whether respondent plead guilty. This term is very important. We have seen in so many matters, our client also, sometimes when he was asked whether you plead guilty, he does not know what is the meaning of the plead guilty. He says yes. So we make the correction. No, you don't accept that you plead guilty, because if you plead guilty, then matter ends. So you have to say, I don't plead guilty. So this question will always come in the first hearing of the proceedings. One more very important thing is, for the early disposal, there is a restriction that normally they don't give the adjournment, or law says they cannot give the adjournment for more than once. But friends, nowadays in these circumstances, pandemic, there are a lot of adjournment are being asked, and institute is giving the adjournment, but very short adjournments are being given, because nowadays on virtual hearings, on the hearings are being conducted on video conferences only. So try not to take the adjournment, but give all the information along with your evidences, proper evidences, so that you should be strong enough to face the committee or the board. See, one thing very important, what I have seen during the proceedings, whether I am for the members, I am against the members, but I have seen the person against whom the proceedings are going on, they are so nervous in the meeting hearing, that as if they had done a blunder. It's not like that. See, you should be strong enough to face the questions of the disciplinary committee, and particularly when you are escorted by the lawyer, they will not ask you much question. Only one or two questions they will ask, then lawyer will argue on your behalf. So be bold and giving your answer according to your pleadings. Pleadings means whatever you said in the written submission, whatever you said in the objection to the PFO. So the hearings will be conducted, opportunity will be given, and oral argument will be conducted. Then order will be passed by BOD for the misconduct, and then for the penalty, what penalty they can levy, because there is some range of the penalties I will discuss. So this is the procedure. And in this procedure, two, three things I told you very clearly. You have to be very, very specific in making objection on the complaint, form one. Then before writing written submission, you have to make the preliminary objection. If evidences or documents are not available in the complaint, you have to immediately write to directed discipline, then provide that document. Without that, my written submission will not be completed. And this, if they don't provide and proceeded further, then you have the very strong case that proper opportunity was not given to me to plead my pleadings or to give my submissions. So this is the procedure for the BOD. Now, disciplinary committee, in addition to the procedure, whatever we have discussed, the parties may give the names of the witnesses. Here, witnesses are examined and cross-examination is done. This is very important. Who should be the witness on your behalf? See, witness can be behalf of complainant, witness can be on behalf of the respondent, and witness can be on behalf of the institute also, DD also. Because if they think that such person has a very important role in this matter, then they can ask that person to be act as a witness. And then witness will give his evidence, and then other side of the counsel, means if it is a witness of the respondent, complainant counsel will cross-examine, or if it is a complainant witness, respondent counsel will be cross-examining the witnesses. And after completion of the cross-examination, then arguments will be had and the order will be passed, similarly for misconduct or penalty. So this is the procedure. See, one thing or very important here, in the cross-examination, you should be very careful in asking the question to the witness, and don't ask irrelevant question by which I think did committee or BOD or whosoever it is will get their time will be wasted and they will be not be taken in a good sense. So only a specific question you should ask to the cross-examination, so that this cross-examination is completed and arguments. In arguments now, I will say one thing very important, because in small matters, it can be done without giving the convenient compilation. But if it's a big matter, lot of 4 or 5 allegations are there, misconducts are there, facts are different, then what I suggest is you should, before the exam, this argument, you should file a compiled, convenient compilation in which your brief submissions, which are you are going to argue, should be written along with the all the evidences, though they are available in the written submissions or their objections, but you again put one convenient compilation, so that it will help to the DC or BOD to refer the document conveniently. I will suggest that thing. So then they will pass the order after argument. for the misconduct or penalty. Now the order, if order is received and we are not satisfied with the order, then we can go, any party can go to the appellate authority. Appellate authority is established for all three institute, ICAI, ICSI, and Indian Cost and Works Account. So this is one authority only. And here, the appeal can be filed within 90 days from the date of communication to the member. But 90 days can be extended, can be allowed, further time can be allowed on the sufficient cause. That is the sole discretionary power of the appellate authority only. Appellate authorities order, if any party is not satisfied, they can go to the High Court. Then from High Court, then the appeal can be go to the Supreme Court. These are these appellate authorities. But what are the power of apex body that you have to say? See, if suppose you receive the order, there are 3 allegations against me. DC has relieved me from 2. 1 is left. Only for 1, I can go to the appellate authority. But one thing is very important, be careful that appellate authority has enough power to revamp whole all the allegations against you, because they have power to confirm, they have power to modify, they have power to set aside the order. They can modify also, they can confirm also, they can set aside also. So you can, the appeal can be filed for the order of the misconduct and then order for the penalty also. So they have enough power. It's not necessary. There can be a chance that if out of the 3 allegations, 2 have been relieved by the DC and 1 you filed with the appellate authority, and after going through the procedure and hearing the parties, appellate authority may set aside the order of the DC, and then you are again guilty for the all 3 offenses. So be careful in filing the appeal. Whenever you are very sure that your whatever is the left in the DC order, if you are very sure, you are strong, then you file the appeal against the order, otherwise not. Second thing, appellate authority can impose the penalty, set aside the penalty, reduce or enhance the penalty also. Here also very important thing is, suppose DC or BOD has levied you a penalty of rupees 50,000 and you go for the appeal. Appellate authority can enhance the penalty also, not the set aside. They can enhance also, they can reduce also. So they have very wide powers. So be careful in filing the appeal against the orders of DC and BOD. They can refer back the matter to DOC for further inquiry and further directions. If they feel that this normally happens when DC or BOD passes the order without giving a reasonable opportunity to the respondent. Or I told you in early that you received the Form 1 or complaint without the supporting document, and you have written to the institute that these documents are very necessary to give my defense, and that documents were not provided by the DD to me, and they proceeded with the proceedings, and you filed the appeal that proper opportunity was not given to me. In that case, if appellate authority is satisfied that the documents required by me were really important to decide the matter, they can refer back matter to the BOD or DC for further inquiry with the directions. So, friends, appeal is provisions are there, but appeal you have to file the appeal very carefully because it can bounce back to you also. So, these are the appellate order for by the appellate authority. Friends, this is the proceeding which I have discussed. This is by ICAI. Now, briefly, I will discuss the NAFRA because NAFRA is also in action now, and it is notified on 1st of October 2018. NAFRA rules were also notified from 13th November 2018. Here, very important thing is I told you, yeah, DC and DD, DC and BOD has no power on suo motu. But here, NAFRA has the power. Section 4A provides the powers of NAFRA to investigate either suo motu, is specifically written, suo motu or on the reference by central government or such class of the body corporate into the matter of the professional and other misconduct committed by the members or the firm of the chartered accountant. So here NAFRA has power. Wherever it has the jurisdiction, for that purpose, NAFRA has the power to investigate either on suo motu or on the reference. What is the jurisdiction of NAFRA? Where NAFRA can take the action is, these are the five class of the companies where auditors related to these companies, where the NAFRA can take the action. Number, all listed companies. Auditors of the all listed companies are under the purview of the NAFRA jurisdiction. But if it is an unlisted company, then there is some threshold limits we have to see. If any one of the limit is stuck or hit, then NAFRA has the jurisdiction. Number one, paid up capital of that company is not less than 500 crores, or turnover not less than 1,000 crores, or if outstanding loans, debentures, or deposit not less than 500 crores in immediately preceding year. So NAFRA has a special jurisdiction, and other than these companies, all the proceedings will remain with the ICAI through the DD, BOD, and DC. Third companies are insurance companies, banking companies, generation and supply of the power companies. These are all covered under the NAFRA jurisdiction. Third is any company incorporated under the special act of the company, special act that will cover. And if any body corporate, company, any person, any class of the body corporate person on the reference from CG, central government, in public interest. Any reference is made that there is a misconduct and it involves in the public interest, that matters will also be covered under the NAFRA. So these are the only jurisdiction where NAFRA can take action. Don't afraid, don't be panic that NAFRA has come. NAFRA has come only for these companies, not for the small companies, private limited companies, or companies which are not covered under this jurisdiction. There, what is the proceeding? They receive the information, your reference, or material on the record. They give this material to the concerned division. The NAFRA has different division. So which division will take care? The administrative division will give to concerned division. then that division will issue the show cause notice to the auditor. Show cause notice must give these following information compulsorily. We have to see that whether these are there in the show cause notice or not when we reply to show cause notice. Number one, under which section or provision of the act this notice has been given. Number two, what are the facts and details of the allegation uh, against the auditor. It will also, show cause notice will also describe that. Then evidences in support of the facts. So whatever allegation and facts have been given, this should be supported by the evidence. And which provision of the act or rule have been violated, this will also be described clearly. And they will also give in show cause notice that authority is taking action, what is the action authority will take. Fourth is, what is the procedure adopted by the show cause notice. This will also know, give the detail in the show cause notice. The auditor will receive such notice, then dispose of the notice in 90 days. There is a time limit provided here for the disposal also. Here also they say the summary procedure, it is a summary procedure, but again I will repeat the same thing. If it's a fit case to examine the witness, if there is a fraudulent document, it's a fabricated document, then NAFRA can allow the cross-examination of the witnesses, etc. Then opportunity to the auditor that they will give complete opportunity to the auditor for the defense. And defense, again, I will say the same procedure. We have to see whether notice is in order. If notice itself is defective, auditor should write immediately the defects of the notice so that they will make the defect good, then again they can give the notice to auditor. So we have to see first whether notice is in order, then we have to give our defense point wise point and give the evidence in support of our defense. Whatever defense we are giving, it should be supported by document, then you will never lose the battle. Then opportunity will be given, and then arguments will be heard, and oral submission will be given. Then order will be passed by the NAFRA. That will be order can be for no action, can be for caution only, or can be for imposing penalty. What are the penalty? Penalties are very, very important. If you see, if it is an individual, rupees 1 lakhs to 5 lakhs. If it's the firm, rupees 5 lakhs to 10 times of the fee received. Second is debarring members of the firm as an auditor, internal auditor, any audit of the financial statement, or debarring the member of the firm performing any valuation under Section 247 for 6 months to 10 years. And how to effect the order? Order shall be effected after 30 days unless provided otherwise with the reason. Means whatever order NAFRA passes the order, it will be effective over 30 days. Because in 30 days, auditor can file the appeal also. Order shall be sent to auditor himself, ICAI, central government, CAG, RBI, SEBI, ERDA, and website of the authority, wherever it is applicable. Whosoever is the complainant, the order will be given to them. How order will be enforced of NAFRA? Monetary penalty will be deposited within 30 days of an order. If appeal is filed, then only 10% shall be deposited. This is must. And if auditor has not complied with the order, such company shall appoint another auditor immediately, deriving from doing the profession, order to be sent to all the companies in which such auditor is functions as the statutory auditor, or such company shall appoint a new auditor uh, in place of such auditor. Penalty for non-compliance of the order: if any order of the NAFRA is non-complied by the order, then section 450 of the Companies Act will be applicable, which says that it's a residual clause for the penalty, which says where there is no provision for penalty in the act, then the penalty will be rupees 10,000, and if it is a continuous offense, then 1,000 rupees per day. So friends, this was my presentation. Any question you can ask, I will be try to give answer for it.
Arun sir, there are the three questions. First, I will start with the first question is from CA Anisa Kazi. Intimation
Just a
sent.
minute, just a minute. I'm not getting any.
So it's in a chat box below.
Just a minute, just a minute.
So should I tell the query? Just
Yeah,
you can.
yeah. You can ask now.
Okay, sir. So it's the first query is from CA Anisa Kazi. Intimation sent to the previous auditor, but the appointment as a statutory auditor.
Yes.
But the previous auditor saying the company not officially informed them of the appointment and asking for the copy of board resolution of appointment to give the NOC.
Correct. So in this case, I will advise one thing. This is not the objection, in fact. And I told you that first, if you have given the communication, he has replied to you, and you feel this reply is frivolous, or it is not impacting any professional reason why you should not accept the assignment. In that case, I will say you just write to the company to provide the copy of the board resolution to previous auditor, and you go ahead with the acceptance. This is not an NOC.
Okay, sir. Second question, query asked by CA Anjali Ghatkar. Can CA appoint a lawyer to represent before disciplinary committee or a board to present his or her case?
Yes. See, nowadays lawyers are appearing on behalf of the members. I am appearing regularly before the BOD and DC as a lawyer.
The next question.
Because rule says that members can be represented by himself, by counsel, advocate, chartered accountant, company secretary. And one thing is there, in first hearing, it is mandatory to appear the member in person, because they will ask that whether you feel guilty or not.
Okay, sir. The next question is from CA Nikhil Porwalji.
I am not hearing anything. Hello? आप म्यूट करें.
म्यूट किया सर. So in case a CA has his good faith and on good relations with the company giving his NOC to the incoming auditor, but thereafter the company has not paid the old dues, what action can the outgoing CA take? In spite of the various reminder, the outgoing CA has not been paid the fees.
See, Amish, I told you clearly in this regard that incoming auditor has to see that the old dues are paid before he accepts the appointment. And I will say one thing, that if you write a communication to the outgoing auditor, you should write in that, please inform any dues of your audit fees against the company, so that before you accept the audit, the dues can be paid. But one thing is there, dues of statutory audit can be, there is a provision for statutory auditors fees, not other dues. For other dues, you have the remedies, recovery remedies available.
So next question is from CA Manthan. Can director pay the statutory audit fees from his personal account when company bank account is not active?
It can pay it, but through the company only. He can deposit in the company's account and pay it. Otherwise, they should pass the resolution that company is not operating the bank account, and then some director should pay for the time being. Then it can be done, but not like that.
Because the account is freeze due to income tax action or something, demands are outstanding. So because it's not possible to revoke the suspension on
Correct.
the
That
bank.
is what I am saying. Hold the board meeting, decide that thing, and authorize one director to pay from own pocket.
Because
But
we are also facing
not
a similar situation where the
Yes,
income tax
I
has
can
freeze the
understand. There
accounts.
are so many such situations. I understand. But you can do one thing. So you can, directors can meet, director can decide
Correct.
that such and such director is authorized to pay the audit fees, and later on it will be paid to reimburse to him.
Acha, sir, one more question in this regard. There is one company, like when there is no other transaction in a bank account since last 3 years. What auditor has done? Auditor has made the provision in the books and has not raised any invoice to the company since last 3 years. So is he disqualified by virtue of not raising any invoice and just showing, just becoming a creditor in his book? So like he's indebted to the company now to the extent of audit fees.
Correct. You yourself given the answer. See, this is correct thing. See, suppose there is no business, nothing, but you are signing the balance sheet. You have to make the provision of audit fees in your balance sheet. Without audit fees, see, nowadays I am appearing in one matter of DC, in which they have not claimed any audit fees for the last 5-6 years, but company is working also. They have not claimed, they have not raised any bill, and then they were doing some other services. For that, they have taken a huge amount. So allegation against them is they are taking huge amount. They are doing a lot of other services in addition to the statutory audit fee. And his reply is, I have not charged anything. His reply is going to his negative.
Correct.
Any other questions from the member? You can directly talk with the sir if anyone, any query is there.
And again, whenever you receive the notice, don't panic. Be carefully, you read the notice, carefully you read the complaint, you read the evidence, then you reply properly.
Okay, sir. Arun sir, thanks a lot very much for sparing your time. Your PPT was also very good. On behalf of Andheri Oshiwara Study Circle, I request CA Anisa Kazi to give the hearty vote of thanks.
Thank you, Amish. Am I audible?
Yes.
Yes, very well.
Good afternoon, Arunji. It was an excellent delivery of the defense mechanism, and it has been very helpful to we all members. We have run through the various authorities and step-by-step procedures involved, which have also included the how to respond to the notice, procedures for adjudication, all necessary steps to be taken, and what should be avoided during the arguments, helpful suggestions and powers of the apex bodies. You have in detail explained through your excellent presentation, and you have explained in through the members' perspective. So even the presentation will cover all the related concepts. So I'm sure that it has been very helpful to we all members and added to our awareness as a members, and the queries also of other members were instantly very well respond to. And it is my pleasure to present a hearty vote of thanks on behalf of Andheri Oshiwara CPE Circle. Thank you so much again, sir.
Thank you.
Good
Thank
day.
you very much.
Thank you, sir.
Thank you very much.
Thank you, sir.